The next case is Mercer versus Mercer. In this case, you're the only person here, Mr. Mercer, so you'll have 15 minutes to present your argument with no rebuttal time, of course. The arguments are being recorded, so when you come up, make sure you introduce yourself. Please stay behind the podium so the video can catch you the whole time you're there speaking. And make sure you speak in a loud enough voice so that we and the video can hear you. You should not use the name of any children. I don't know really in this case if there are any issues about your children. Any minor or victim during your argument, you can refer to them by initials or term like the child. We read your brief. We're ready to proceed whenever you are.
All right, good morning, Your Honors. May it please the court. I am Robert Mercer. I am the appellant and plaintiff in this case, and I am appealing the judgment entry final decree of divorce that was issued in June of 2023, as well as the amended temporary orders that were issued in June of 2021, and the motion to set aside that was denied in November of 2023. And the way I've organized my brief and the assignment of errors is basically assignment of errors 1 through 6 go to the amended temporary orders, and the assignment of errors 7 through 12 go to the final orders. Now, unfortunately, assignment of errors 5, 6, and 7, we don't have a signed agreement on that, so I would ask this court, pursuant to the Ohio Rules of Appellate Procedure 18C, which states in part that the court may accept the appellant's statement of the facts and issues as correct and reverse the judgment if the appellant's brief reasonably appears to sustain such action. The appellee, Maria, did not contest that in her brief, and she's not here to argue it orally today.
Well, I understood that at least at some point there was a mediated agreement on 5, 6, and 7. Is there a mediated agreement but not yet signed? Is that what you're telling us?
Correct, Your Honor. But there's a question as to whether it may still be signed. So negotiations are ongoing. I know we're not supposed to bring them up into the court.
Fair enough. That's sufficient to explain. Thank you, Mr. Mercer.
Yes, Your Honor. And then I just cite on the 9th District, Weber versus Oba, which is back in 2005. So with that being said, Your Honors, we're here today not because Robert just didn't like the ruling of the court, okay? We're here today because Robert is asserting that the trial court's rulings were unlawful. And very specifically to begin, during the case research, one of the things that I found that I really want to open with is the Ohio Supreme Court. I can't think of a better court to give us guidance on this matter. And in 2021, under Johnson v. Abdullah, at paragraph 39, this is the Ohio Supreme Court speaking, it says, "We take this opportunity to make it clear that courts lack the discretion to make errors of law, particularly when the trial court's decision goes against the plain language of a statute or rule." And these are the issues I'm going to present to you briefly that are also in both my brief and my reply. Just some quick background so the court's aware. There is a de facto termination date of marriage, January 14th of 2021. That did involve a TPO and a DVCPO, and so the parties started in January of 21 with very separate lives, not just physically apart, but also bound legally to that standard. The complaint for divorce wasn't filed on February 1st. In the matter, and then there were temporary orders issued that seemed to be overlooked by opposing counsel and the trial court judge on March 25th. We did have a passing of the judge, and there was some confusion with the COVID and whatnot. So by the time we got moving forward, at that time it was assigned to a magistrate, and we had a case management hearing on April 7th, and it was at the case management hearing where Robert found out that Maria requested a Rule 75 in hearing on the temporary orders, which were already issued. So Maria not being compliant with the Ohio Civil Rule 34, request for production of documents, basically Robert subpoenaed her banking account statements. Unfortunately, he did not get them until 6 days after the hearing. The banking account statements pretty much show that
Was there a request for continuance of the hearing on the temporary orders because of lack of information at that time?
No, and partially part of the issue there as well was the fact that, and I want to get into the actual transcript of what the magistrate said on May 7th, 2021. The magistrate said, "Before we got started, you all agreed that it would look at the financials, and these are sworn affidavits." So Robert felt reassured that the magistrate said, "Hey, these are sworn affidavits." So it's kind of difficult to think, we don't have the bank account statements, but how far off is Maria willing to go? Would she completely, defraud the court? We weren't thinking along those lines. We're thinking that, hey, if there's something amiss or if there's a problem, we'll go ahead and have a chance to rectify that later. the court was pretty clear it was gonna go based off of the affidavits. So I hope that answers your question. But again, once we see what the issue was with the false financial affidavit and the testimony she said to support it, Robert, of course, filed the motion to set aside. And that was denied. And I just want to give this court a feel when Robert asserts just how contrary the court ruled to itself. It doesn't do itself justice until I can just kind of read from the transcript here. So please indulge me for a moment. So at the motion to set aside hearing on November 3rd, 2021, page 26, lines to 1425, the trial court judge says, go back and look at the temporary orders. Order does indicate that offsets, okay, will be addressed at final hearing, all right? The temporary orders specifically indicate to you and Ms. Mercer if any adjustments or offsets need to be made, okay? They will be made at the time of the final hearing. So you have not lost your opportunity to be heard on the offsets, okay, or any credits, because if you review your temporary orders, the temporary orders specifically indicate that the parties will be given an opportunity to do that at the final hearing. So it wasn't addressed at the temporary orders. That's what we have at the denial of the motion to set aside. Now, fast forward 10 months, day 2 of the trial when Robert is on the stand. This is the September 12th, 2022 transcript. Page 66, starting at line 10. Now the judge says this, no, not doing it. Again, the objection to that has been ruled upon. The temporary orders stand. I'm not going to provide you an opportunity to relitigate that. And that's why Robert has this idea that his right to be heard wasn't heard. In fact, there's no judge or judicial officer that has heard this issue until today. The three of you are hearing this right now for the first time. What really made this egregious as well, Your Honors, is that when you look at the transcript from November 3rd, from that motion set aside hearing, the trial court judge acknowledged that the child support order anyways was unlawful. And I quote from page 19 of that transcript. The court recognizes that the magistrate may not have included spousal maintenance order as other income on line 11 as argued by the plaintiff. So the trial court judge understands that it wasn't calculated correctly.
And the trial court, in their final decision, made some effort to attempt to cure that by taking the, by finding spousal was overpaid for a period of time and going back, I think, a year and saying we're going to look at that number, and the child support was underpaid and finding that to be child support arrears. So the trial court made an effort. Are you saying the trial court's effort is not satisfactory in some way?
Correct, Your Honor. Let me explain why. Because the de facto termination date of marriage, we're talking about almost 2.5 years. And the trial court arbitrarily, right, we're going to Blakemore v. Blakemore, arbitrarily says, hey, this 12 months we're going to give you that credit, okay? These 14 months were not. So not only is Robert not receiving credit for 14 of the 26 months that the trial court looked at, but that the trial court also failed to properly look at that spousal support. I'm arguing that spousal support.
And did that May 22 date, I think the trial court selected, as I recall, was that coincide with any decision on the setting aside the magistrate's order or any other fact in any other date in the court that makes some sense as to why the court picked the 22?
It does. It makes sense only in the sense that it was actually May 23rd and 2022 was the start date of the trial, day 1.
Okay.
So without a de facto termination date of marriage, normally the temporary orders, that's where the termination date would
So the trial court took it to the start date of the trial. Very good.
Yes, Your Honor. So, so I'm basically arguing that these are, that these orders need to be remanded, the amended temporary orders. Now, I just want to go quickly into what the actual legalities are, right? What is what part of the law? So when you look at assignment of errors 1 and 2, they speak for themselves. The spousal support underneath number 3, I basically refer to the Ohio Revised Code 3105.18C1, which states in part that the court shall consider all of the following factors. Subsection A is the income of the parties from all sources. Unfortunately, Ms. Mercer, Maria did not, on her financial affidavit, list her unemployment benefits, okay? And when you look at the banking statements, more money was going in her bank account than what she put on her affidavit. Now, I cite to Doubler to support this. Paragraph 19, this honorable court stated that this court has previously held that failure to consider income from all sources pursuant to RC 3105.18C1A constituted an abuse of discretion, and this court pointed to CS VMS. And we can find this on the record in Exhibit BB and Exhibit M. BB is her financial affidavit. The child support as well. The admitted child support, RC 3119.02 talks about that in any action in which a child support order is issued, they shall calculate the amount of support with the basic child support schedule, the applicable worksheet, and other provisions of Chapter 3119. What wasn't followed, obviously, on this was 3119.01C12, which like 2 weeks ago, they made changes, so it's now 13, was the unemployment insurance benefits and the spousal support actually received. They're not there. Okay? Magistrate couldn't have known that she was going to commit fraud on the court with the false financial affidavit, but most certainly, while the magistrate did deduct the spousal support actually received from Robert's income, didn't add it to Maria's income. This was further exacerbated by RC 3119.05P, which is child care. Because of the protective orders, Maria cannot help with child care, so Robert had to have these children, other than 2 hours a week of supervised visitation.
And let me know, Mercer, you're at the 10-minute mark at 5 minutes left.
Thank you, Your Honor.
And let me move you along, if I could, to the question of the bank accounts. And I think that's assignment of error number 8.
Yes, okay.
So you're saying that the trial court has some figures in their decision that are just flat out wrong, they're inaccurate, and that you supplied us the correct figures in your brief.
Correct, and the reason for that is the de facto termination date says January 14th, 2021. It doesn't say January, the end of the banking statement records. It doesn't say January 17th or 18th. January 15th happened to be a payday for Robert. January 14th was a Thursday, it was not, okay? So the trial court put those bank account balances at $2,200 above what it is. Then,
How do we I had a brief opportunity to review the exhibits in this case, and they seem to me to be bank statements for the month of January, let's say, that have a starting date of X and an ending date of Y. And then in there, there's some balance dates on January 10th or 14th. Are you indicating that those records had clear statements of the balances on January 14th?
they do. They list by last activity. So if you have the banking account balances from January 10th and then January 16th, you use the balance on the 10th. From the 10th to the 16th, that's what the daily balance was. Okay? So you can easily go to that specific date and say, this is what the account balances should have been.
Okay.
The other issue with that, Your Honors, is that the judge then said, Robert is in possession of all these banking account balances totaling $15,000. They didn't, it was 12 something. And Miss Mercer was clearly, the exhibit in, that's her bank account, PNC Bank, and she had like over $3,200 in that account. Why is Robert giving her $3,200, or at least half of it, when she's already in possession? So it was basically miscalculated. That was assignment of error.
Well, I understood the trial court to be saying, because she was in arrears in child support, that you would be getting the what PNC Bank, whatever it was that was in her name, that would be going to you. I understood the trial court.
The trial court offset
Right.
the child support that she owed by saying, well, Robert kept 15, Robert owes Maria 7.5. Well, even if
Maria owed you 7.5 for the bank accounts. I got you. Okay.
for the bank accounts, yeah, Maria owed me 7,000. So the trial court said you have to pay her 7.5. We're going to offset 7,000 in child support from the 7.5, meaning I owe Maria 500, but Maria kept 3,200 of that. That wasn't calculated. It severely changes that.
At least as of trial, were there any funds left in that PNC Bank of Maria's, or do we know?
We don't know because she
Okay.
continued to use it, and by that time it's separate property. We're using our own money for our own things. Yeah, definitely. So yes, that was done incorrectly. Now,
You're
because,
right now at 2 minutes left. So.
okay, well then because of that, I'm gonna just basically go on the child support. I already talked about child care. Doubler v. Doubler, 2023, paragraph 24, this court has held that trial court's failure to credit as income spousal support paid. That's also an error of the trial court. The daycare costs, which are also assignment of error 11 and in 4, Varner v. Varner and Sayak v. Sayak, you both have said that those are abuses of discretion. So the brokerage account number 9, splitting the same asset twice, you get 75% to Robert's 25, that's not correct. And I really needed some time. I wanted to talk about
On the brokerage account, how does the court get the figure of $851? Is there some testimony that that's one half of what was taken out of the Alta Bank accounts? Or
correct. The trial court's finding of fact says that the brokerage account was funded from the parties' marital funds, which they just split. It came from that account, and then it divides that the same exact asset a second time.
You agree that the 851 is half, you just think you were in essence double dipping by the court by assigning it to you in one place and assigning it to you in the second one.
Correct, that's exactly what the court did.
So 851 is the right number, that's not wrong,
It's the finding of fact, yes, Your Honor. So the last thing I think I have time with just a minute is basically, if you just review Sayak v. Sayak, It's the earnings ability. I just want to state that, interestingly enough, in the court record at SEAC, I'm going to skip all this and go down. The trial court, the vocational expert in SEAC is a Mr. Mark Anderson. He provided a vocational report. He's the same one I have. I found him in SEAC, and so I hired him back in 2021. And when the trial court, if the trial court would have said, hey, Maria's going to be imputed or have earning ability of $34,260, we would not be here today. Robert would feel it's abuse of discretion. He would not like it, but it would not be something he's appealing because at least it's within the range, the very bottom of what Robert stated. And so I believe that the trial court just arbitrarily pulled out $30,000 and just disregarded. And the last thing I'd like to state for the record is this is a de novo standard of review, and SEAC, paragraph 26, this court said when the issue on appeal is whether the trial court correctly applied the child support statute, the court employs a de novo standard of review. And so what I'd like to ask this court to do is the trial court is rife with mistakes, mathematical mistakes, calculation mistakes. The evidence says this is how much money was in the bank account. The court's clear what it wants to do, but then it fails to properly divide those assets, or it divides the same marital assets twice. The trial court supported the vocational
Mr. Mercer,
expert.
your time's up if you would briefly conclude.
Okay, so the trial court basically supported the findings of the vocational expert and then just pulled a figure, random figure out. So I would ask this court to reverse remand and give instructions for the trial court to please review this and correct the errors that the court made at both the amended temporary order stage and in the final order stage.
Thank you, Mr. Mercer.
Thank you, Your Honor.
The court will take the matter in advisement and issue a decision in due course. When that decision is reached, the clerk will mail a copy of it to you. It'll also be posted on the Ohio Supreme Court website at that time, as will today's argument. Thank you, sir.